Hello, hello.
And welcome to the Hildebrand Law Firm topic for today.
I'm Kirsten Hildebrand.
And I'm Matt Kaplan.
And today we're going to talk about a modern issue, and that is, should you have a will, power of attorney for healthcare, power of attorney for financial, and or a trust if you are unmarried but you have a significant other? And we talked about before this what we should call that significant other. And you mentioned that there might be a contemporary term for this that I was unaware of. And what is that, Matt?
Yeah, I like the term player two.
Player two. Okay,
Yeah.
So what does that mean exactly?
So like when you play video games, you're player one, you're the main character. So you have a player two.
Now, when I played DDR with the kids, was I player anything?
It depends. Did you play co-op?
I don't even know what that means. I just did Dance Dance Revolution. That's all I ever did. Oh, and we did Wii bowling.
Oh yeah, Wii bowling, yeah.
Yeah.
So Wii bowling, if you're playing by yourself, you're player one.
Yeah.
Playing with somebody else, they're player two.
Okay. Well,
And
so
so-
are we speaking to player one or player two today?
I think we're speaking to the whole gambit, but mainly one and two because
One and two.
they're each other's.
Okay.
Because player two is relative. So like, my wife, she's my player two, but I'm her player two.
But you're also married.
That's true.
So you're not really player one and two. You're just together.
Well, I used to be a player.
You're like on the same team.
I used to be a player, but...
Okay, maybe we should just talk partner.
Okay, partner.
Like, let's just
We can do
call them
partner.
partners. Okay, all right. So let's talk about these partners. So you have a situation where perhaps you have moved in together, maybe he is on the mortgage and she is not, but she is contributing to the mortgage, or she is paying all of the other utilities, and perhaps they both have individual credit cards that are being paid for out of a joint account that's owned by each of them, or there's cars, sometimes there's children, sometimes the assets even get really, really significant. What's the longest client that are living together as partners that you've experienced?
That I've seen 20 to 30 years.
Yeah, I would say the same. I want to say I think the oldest is maybe even 35 years that I ran across. So sometimes these relationships can really be very long term, and you can just imagine after 20, 25, 30 years, the investment, you're really intermingled.
Oh, yes.
And so just imagine this. Now you have not put any estate planning in place, and one of the players or partners passes away. Now, what are the legal ramifications of that? What rights does the now sole partner have towards those assets?
Legally?
Legally.
I'm thinking none.
It's really slim, yes.
I'm thinking they have to make an argument to the judge.
Right.
If there's nothing in place that, hey, we were essentially married. I mean, everyone's heard the term common law marriage, I'm sure.
But Wisconsin does not recognize common law.
Right, and some states do. Wisconsin does not. But there's still a
What
lot.
about domestic partnerships? So if you are a registered domestic partner in Dean County, which recognizes them, and I don't think that there are any other counties in Wisconsin that recognize a domestic partnership. So that would put you in the category of perhaps having some limited legal rights relative to this. But in the vast majority of Wisconsin, there are zero legal rights. You're absolutely correct. There is a way to make a claim against the estate. We have done that for people before, but now you're really behind the eight ball. Now you're really coming at this out of a position of weakness. So let me just explain that a little bit better. If somebody passes away and there's no estate planning in place, the intestacy laws that would apply do not have any room for a partner. They simply don't. So who comes in? Mom, dad. They're the ones that inherit. And if mom and dad are not around, then it goes to their siblings. But so now mom and dad come in, and let's say it's a 35-year-old son that has passed away, they're going to come in and they're going to want everything, and they're going to grab everything because they don't have any real connection or tie to this partner that has now been living maybe for say 10, 15 years, but they never decided to make this legal. It puts that partner at a huge disadvantage. So then what is the only way that you could potentially gain some assets back from that situation? It would be to file a claim against the estate once a probate is opened up, and then you have to support that claim. You have to show evidence of having paid these bills or taken on this financial responsibility, and that gets really murky. So you're going to have to prove I was paying 50% of the mortgage all the time, so I should be getting 50% of the value since the day that I started making those contributions.
Wow.
And then there's also the complication of, well, how did you make the contribution? Oh, I just gave him cash every month. Whoops. Now you've got a major problem, because there's no way to trace that cash, and getting a judge to believe that that's how you spent your cash is a whole nother kettle of fish, right?
Right, and just imagine being in a relationship with someone for that long. You haven't technically gotten married, but you're as married as anybody else, you know, in your eyes, and then they pass away, and then all you go into is fight mode. Fight, and going back to what you just said, you then have to prove your relationship to a judge
Right.
who is a total stranger.
Yes.
You have to prove to that judge that the last 20 or 35 years, like you said, we were in a real relationship, we were doing things like married couples do, we just never actually got married. That's got to be just soul-sucking. That's got to be terrible.
So there's a really simple solution to all of this.
What would that be?
And that would be to do estate planning. It's very simple. And so if you were to come in and say, I want to make sure, because in the state of Wisconsin, you can name anybody to be the beneficiary of your assets if you take that step and actually come to a law firm, come to Hildebrand Law Firm, and have your estate planning done. That takes away all of those problems, because now you are exercising your right to name somebody to be the beneficiary of your assets. And so in this instance, you would then write out a will or a trust, and you would say, this is the individual whom I want to receive everything. Now, in that instance, the question becomes, will the parents or the siblings or somebody else in the family try to contest that will? And if you think that may happen, then it might be a much better idea to put a trust in place, which would then require them to find an attorney and actually open up a probate action in order to then contest the trust. So that's a lot more process before actually being able to engage. Whereas with a will, you're essentially asking the court to oversee that, and then you would have to notify all of the interested parties of the fact that the partner is named and ask them to sign a piece of paper saying, I agree with that will, I'm not going to contest it. So that really becomes a very important process then, and an important decision to make as to whether you want to go towards the direction of a will or towards the direction of putting a trust in place for your partner.
Yeah, fascinating. And one other thing that I want to mention, why it's important to really understand the difference between being married and not being married, especially in Wisconsin, is from the eyes of Medicaid. If you are married under the eyes of Medicaid, Medicaid allows you to keep so much more of your money. If you're married, if you need to have long-term care and you apply for Medicaid, you can keep so much more. You can move money from yourself over to your spouse. Your spouse is allowed to keep a lot of their own money. For example, they can keep their entire retirement accounts.
Have you ever known anybody to get married so they could get the Medicaid allowance?
That's a good question. I don't know. I haven't known anyone who get married to do that, but I have heard of people who have asked me, should I get divorced for Medicaid reasons?
And the answer is
Heck no.
it used
Heck
to be
no.
that attorneys were running around giving that advice, though, and that's why people ask that question, is because it used to be that attorneys thought that there was a loophole there where you could have all of the assets moved to one of the spouses, get the divorce, and then the spouse who just has a couple $1,000s, now ex-spouse who has a couple $1,000s, can now qualify for Medicaid. But Medicaid has blown the whistle on that and says, well, then that's just a false divorce, and they're still going to come back and grab at least half of those assets.
Yeah, but getting married for Medicaid purposes is not a bad idea.
Yeah, now that we think about it, right?
You know,
we might want to start advising people to find someone to marry, and then they can take more of an allowance.
So it's not a bad idea. Yeah, it's weird, especially the state of Wisconsin being a marital property state. They allow for Medicaid purposes. You're not one cohesive unit like you are everywhere else in the law in Wisconsin. You're two individuals, but you can transfer money from the institutionalized spouse over to the healthy spouse.
Mm-hmm.
But the problem is, if you're not married, then that threshold goes from, I think it's around $150,000 that the community spouse is allowed to keep. That threshold completely goes away because there is no community spouse because you're not married. That threshold goes down to $2,000. If you transfer money from yourself to your partner, that is an uncompensated transfer. That's a divestment. You're going to get penalized for Medicaid purposes. And so you could be living together for 30, 40 years and not be married. But in the eyes of something like Medicaid, you're a single person.
Mm-hmm.
And so then the rules apply to you as if you were a single person.
Are you advocating marriage?
I typically don't, but
even though you are, in fact, a married man.
I am. It was the right move for me. I'm very happy, but no, I'm advocating for. I think when I get a couple in here that had been the term is happily unmarried for X amount of years. I appreciate that they broke the mold. They didn't do what everybody told them to do. They did what was right for them or what they think is right for them, and so. I'm totally on board. If people don't want to get married, but they want to spend the rest of their lives together, good for them. I just want people to know that there's certain ramifications.
You have to take certain steps because the law automatically protects married people in a multitude of ways, and we've just touched on a few of those, and you have to compensate for that if you choose to remain unmarried.
Yeah, but it's as simple as just you get your estate planning done. You're good to go.
You're good to go. All right. Well, thank you so much for joining us today. And we are here to protect your today and your tomorrow. And we will look forward to seeing you next time.